Due Process, recipient of 5 Mid-Atlantic Emmy Awards since 1997.
Nathaniel Abraham should be found guilty of first-degree murder.
A prosecutor's pitch to a jury in the trial of a kid who killed at age 11. And the bottom line question in juvenile justice:
What about a child who kills?
should young offenders be tried as adults? On this edition of Due Process.
Major funding for Due Process is made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding is provided by Lawyer's Diary and Manual.
A 15-year-old in Ocean County rapes and murders an 11-year-old neighbor. A Sussex County 17-year-old takes part in the thrill-kill shooting of 2 unsuspecting pizza delivery men. An 11-year-old in Michigan tells a friend he's going to kill someone. He steals a gun, fires, and another boy is dead. They're the kind of shocking crimes that have led to new law that treats increasing numbers of juveniles as though they were adults, even when the charge is something short of murder. I'm Raymond Brown, and on the docket for this edition of Due Process, trying juveniles as adults. It's a legal policy and practice that inspires strong feelings, as we'll see when we talk with 3 experts who are on the front lines of juvenile justice. But first, here's Sandy King with a look inside the courtrooms and the cases. Sandy?
Raymond, these are courtrooms we would never see, and names we would never know if these kids were being tried behind the closed doors of juvenile court. But that may be the least important difference. More to the point, a kid tried in adult court is subject to adult charges and sentences and prisons. Only the death penalty is off limits for kids who've been waived up, and in New Jersey, they may be as young as 14.
This is the arraignment of Rainbow W. Hefner. It's indictment number 0003.
An arraignment for murder. The defendant charged with killing his mother just 1 day after his 17th birthday.
We acknowledge receipt of the indictment, Your Honor. We'll waive a reading and enter a plea of not guilty.
This is Superior Court, adult court, with adult penalties looming. Rainbow Hefner has been waived up. The day when a minor might have gone no further than juvenile court on these or lesser charges, long gone.
You also have a right to a jury trial. Do you understand those rights? Mr. Hefner, do you understand those rights? You want to speak or no?
Once someone is waived up, they're treated as an adult, and the chances of being rehabilitated in the future drop dramatically.
I think that it plays a role in the reduction of crimes, and I think that in the current climate with the amount of violent crimes that are being committed by juveniles, that there's a role to be played by the waiver.
But if those are the arguments when the defendant's 17, what happens when he's not yet in his teens?
You can bring in the jury in.
Nate Abraham, too, was charged with murder, the shooting death of another boy, when Nate was just 11 years old.
This case involves the law of murder and the law against assault with intent to murder. I want to discuss with you that law a little bit because the question comes to mind, what about a child who kills?
The state of Michigan answered that question by trying Nate Abraham as an adult.
Nathaniel Abraham should be found guilty of first-degree murder and assault with intent to murder.
He may have been the youngest child ever to be tried and convicted as an adult. That could have meant the rest of his life in prison.
I'm standing here today to protect a child from the overwhelming forces of government and the false accusations that were made.
In the end, the jury called the child guilty, but the judge stopped short of a grown-up sentence. Nate Abraham, now 14, will be held in a juvenile jail for 7 years, then released at 21 whether or not he has been rehabilitated.
Joe Galera's death was caused by this defendant's own personal and purposeful conduct.
But in New Jersey's Sussex County pizza murders, the judge didn't buy the likelihood of rehabilitation for Jason Vreeland. He was 17 when he and Thomas Koskovich, now on death row, ambushed and killed 2 pizza delivery men.
By firing a gun into that vehicle, he may have acted recklessly, but not knowingly and purposely.
Or is that just another instance of Jason Vreeland attempting to minimize his own conduct and place all the blame on Thomas Koskovich?
Vreeland was convicted, and though his juvenile status precluded the death penalty, the judge hit him hard with life plus 46.
15-year-old Sam Manzi will now be tried as an adult following the waiving of his probable cause hearing this morning.
And Sam Manzi learned, too, that being a juvenile may not bring any breaks.
He snapped. And as a result of that snap, as a result of that act, we're here before you.
His crime, the rape and murder of 11-year-old Eddie Werner, who came to Manzi's house selling Christmas candy and never got to go home.
I proceeded to strangle him with an electrical cord from an alarm clock.
For how long?
Approximately 40 minutes.
Manzi pleaded guilty, and there was nothing juvenile about his sentence.
You, and you alone, have the privilege of making sure that Manzi never does this again.
The sentence, 60 years in state prison, thanks to a waive-up law that just got tougher, and not only for murderers like Manzi and Vreeland.
There would no longer be an opportunity for the juvenile to be heard through his or her attorney before the judge makes a decision. Is that correct?
Effectively, the answer to that question is yes. For those certain specified crimes, it would no longer make a difference whether or not there was a potential for rehabilitation found before the age of 19.
And before it passed, it drew some spirited debate on the assembly floor.
This bill says we give up on our children.
It will hit our poor, it will hit our black, it will hit our Latino.
But these crimes are being committed against minorities as well, and we need to protect the people from these violent criminals and treat them as adults.
I don't look at this as a black-white issue, Hispanic, non-Hispanic, white issue. Too long have we had this bleeding heart liberal attitude that young people can do no wrong. They do commit crimes. There needs to be accountability.
In the end, the bill passed easily. It is now the law. It has made it much more likely that a juvenile will be waived up, and not just for crimes like kidnap, rape, and murder. Drug crimes, car thefts, or any persistent delinquent behavior can land a kid in regular criminal court, where the emphasis may be less on rehabilitation, Raymond, than on punishment. As for who will actually get waived up, that, more than ever, is in the hands of the prosecutor.
And Sandy, we'll hear from one of those prosecutors on why waive-up makes sense, from a criminal defense lawyer who has defended waived-up juveniles, and from a state legislator who works with juvenile offenders every day. So stay with us.
I think they should go to an adult prison. If they're old enough to make a decision they want to take somebody's life, they're old enough to do the time like a real adult.
Depends on the crime. More heinous the crime, yeah.
They should be treated as an adult and be put in jail and stay there, so innocent people would not be harmed.
The adult jail is different from, juvenile jails, It's more serious, and I don't think a child can handle all that.
They don't know the difference between right and wrong.
What makes kids any different besides the fact that they're younger? They know what they're doing anyway.
I don't think he should be tried as an adult, but I think he should be punished.
If they're old enough to murder, then they're old enough to take the consequences.
They see the things that's going on TV. I mean, they know right from wrong. So, and they chose to go out there and do it, they should be tried as an adult.
There is an increasing public unwillingness to put up with juvenile crime, and so, according to a Star Ledger editorial, kids have been abandoned to the mercies of adult convicts with little regard for rehabilitation. Patrice Davis is the Chief Assistant Prosecutor in Essex County for the Juvenile Sex Crimes and Family Division. Patrice, what do you think about the Star Ledger's characterization of our juvenile law, that essentially we've abandoned them to the tender mercies of hardcore adult convicts?
I think that's a misstatement. I think that most people would agree that there are special facilities for juveniles where they're held in facilities for younger offenders, and that we are not abandoning them to the mercy of adults.
Barry Albin, you're an experienced criminal defense lawyer who has represented juveniles who've been waived up. I should point out that you're a past president of the Association of Criminal Defense Lawyers, an organization to which I have belonged and been a president myself. But are you among the people who agree with Patrice that this is a system that does have regard for the possibilities of rehabbing young possible offenders?
I think it does have a regard for the rehabilitation of offenders, but unfortunately, with the new law that has passed, we're going to see mass waivers of juveniles between the ages of 16 and 17 for mundane offenses, not sensational offenses. For instance, the charge of aggravated assault, which could be nothing more than a person who has been provoked, perhaps by racial epithets, to punching another person's nose and breaking it, now will be subject to automatic waiver to adult court if the prosecutor chooses. And I think that that's a very bad social policy. And we're taking the judge out of the decision-making process. And unfortunately, we're going to be left to the kindness of prosecutors. And our system of government and our system of justice is...
What would you say to a citizen who said, well, we need to do that because juveniles do commit serious offenses. If the offense is potentially a serious one, why not treat them as an adult from purposes of deciding whether they're guilty or not?
Well, there may be appropriate cases for treating a juvenile as an adult. But what we are doing increasingly is taking the judge out of the mix. The new law requires automatic waiver of 16 and 17-year-olds to adult court on motion of the prosecutor. There will no longer be a weighing process on the part of a judge to determine whether or not there's a probability of rehabilitation. What we are going to be doing is consigning juveniles in many cases to the trash heap of our adult penal system, and that's poor social policy.
Well, let's examine what Barry's saying in terms of consigning juveniles to the trash heap, because rehabilitation is not such a favored word in our law at the moment. Mary Previty, not only are you an assembly person, but you are the administrator of the Camden County Youth Center, which is the juvenile jail in Camden County.
Right.
Tell us what rehabilitation is. Is it a lofty theory of starry-eyed liberals, as some of your colleagues in the assembly suggest, or is there real meaning to it?
Rehabilitation is talking about making our streets safe. Now let's take a look at what waiver does. That waiver means we're going to send youngsters to adult prisons. What are the results we want? We want to be safe. We want to be safe in our neighborhoods. We want to be safe in our streets. Now we've had a lot of states that have already done this. We've been putting youngsters in adult prisons in Florida. We've been doing it in New York, in Minnesota, and there have been wise people that have studied the results of this. And what are the results? Found out in Florida particularly, we've seen it in New York and in certain cases where we compared two sets of children. You compared this youth that is going to be kept in the juvenile system, in the family court system, in juvenile correction centers for doing his time. You've matched an exact same kid, same charges, same number of crimes, same type of charge, put in the adult system. And what do you think the results were? The results were that youth in the adult system, when he went back to the streets, was more likely to reoffend more quickly than the one that was kept in the juvenile. And there are good reasons for that.
Patrice, the other thing that the Florida study showed, just so that you can respond to all of it, is that there was also a marked increase in the numbers of African American and Latino youths who were treated more severely. So now there's a bunch of things that have come out of a study. Why does that not influence you to not favor the concept of waiving juveniles up in New Jersey?
Well, I think that first of all, I think that I'd be remiss if I said that I think everyone who's charged with a serious crime should be waived up. That is not the position that most prosecutors take. What the position of the prosecutor is that there are certain kinds of cases which, for the reasons of the seriousness of the offense, the types of harm done to the victim, and the likelihood that the person is going to reoffend, which require more incarceration than is available in the juvenile justice system. A person who commits an armed robbery as a 17-year-old with 11 months, and 17 years old and 11 months, is facing 4 years in the juvenile justice system versus 20 years in the adult system.
That you work in one county and you're not yet the Attorney General of the state.
That's
so
true.
That much as we might have confidence in you, how can we be satisfied that in a state like Florida, where prosecutors have had the kind of discretion that's similar to the bill in New Jersey, there have been a remarkable racial bias in the way that's been exercised? Maybe not consciously, but certainly in terms of the effect. I mean, how can we be certain that isn't going to happen here?
Well, nothing is certain.
Well, but there's reason to believe.
But I think that the question is there an offense which you think is so serious and the damage to the victim so serious that it requires treatment as an adult? And the question then becomes, if the law has been used disproportionately, if there is a lack of due process or unequal treatment, then there are means to address that.
But it's one thing if a judge is making a decision. Our system gives wide discretion to prosecutors. And let me just follow this up because, again, I come back to the fact that those of us who know you have a lot of confidence in you personally. But when we look at the whole system, this bill, for example, would permit children or juveniles to be waived up for non-serious offenses if, for example, they have a prior offense or if they've been incarcerated in the past. So it isn't only necessarily people charged with murder or a life-threatening offense who are going to be waived up. How can we be certain that this discretion is going to be exercised wisely around the state?
But this bill doesn't change. That part of the bill is not different than the prior part of the bill. There was a prior provision in the other bill which permitted the prosecutor to make a motion based on the number of offenses, and the judge made the call on that. And this is going to be the same case for this bill that's coming down the pike as well.
Barry, are you confident that this is not going to result, this bill, in waiving up of juveniles who would not otherwise have been waived up and be treated in a manner that suggested, at least by the ledger, puts them in a serious prison environment as opposed to a rehab facility?
I'm confident it's going to increase the number of waivers. The Attorney General is supposed to promulgate guidelines, and I think that we will probably get pretty draconian guidelines statewide. The decision used to be made by a judge who determined whether or not there was a probability of rehabilitation and whether or not that probability of rehabilitation substantially outweighed the reasons for waiver, which were typically specific and general deterrence. Now the prosecutor, within 30 days of the filing of a complaint, will have to make a decision whether or not there's a probability of rehabilitation and whether or not it substantially outweighs the reason for waiver, and there will be no judicial accountability. Now that isn't a sufficient amount of time to make an informed and intelligent decision, and what we're going to see are rash moves to put juveniles in not so serious offenses up in the adult sphere, and we're going to see it in greater numbers.
Mary, you're in the. Let me just ask Mary one question.
I have to jump in.
Oh, go ahead.
I have to jump in.
Go ahead.
Nobody on the street, not one person in my neighborhood where I live, cares about, is it a prosecutor, is it a judge, is it a public defender, is it a mumbo-jumbo of the court system? They want to know, is what we're doing going to make my street safer? Is my daughter safer walking up the street under this system, or that's what we want to know.
And I take it you agree that's a legitimate concern.
It absolutely is. And what are the results? We are looking at wise, scholarly people who have studied what has happened in states that have done this kind of thing that we have just enacted in this state. And they said you get bad results. The kid goes out and does something worse. Almost none of them go forever. It's almost unheard of for a youngster that is tried as an adult and goes in an adult prison that stays forever and dies there. Doesn't happen. They come back into the neighborhood. Why in the world would we support something that is going to give us a bad result, make us less likely to feel safe on the streets? It boggles my mind.
Well, how do you explain the widespread public perception that we coddle juveniles, that we don't take seriously offenses that they commit? Why is that so widely held a belief among the population and among your colleagues in the Assembly?
Oh, I think that there is widespread frustration because we are fed a diet of increasing juvenile crime and increasing juvenile crime. It isn't happening. Those of us who are looking the numbers of saying that juvenile crime and even serious juvenile crime has been going down for almost the last decade. So we've invented a punishment for some of the crimes that aren't even there. And there are youngsters that are not even being committed real serious crimes that are going to be caught in this net. Let me explain why kids are more likely to get into big trouble when they go into the adult system. We're doing it because we think it's good. We think we're going to be safer. We think we're going to get better results. We're throwing an impressionable person, 14, 15, 16, 17, during the time when the building blocks of their development are getting in place. You're learning how to socialize. You're learning how to get along with people. All the different pieces that are in place. At that moment, we're going to put somebody in an adult prison where the rule of law is the rule of violence. So you are going to shape this human being that is in the most moldable time of their life in an adult institution where their teachers and proud professors are going to be violent felons that are just going to shape them for the world when they walk out. We found out that they have poorer marriages, they become poorer
parents. Let me hold on a second, because I have a sense that Patrice doesn't agree with everything you said. Patrice?
No,
okay,
I don't.
Go ahead.
First of all, the study was flawed because it didn't really look at, it looked at how serious the offense was or when the person reoffended, but it didn't really look at how many offenses the juvenile offender had an opportunity to commit because he was incarcerated for a substantially less period of time. But let's go really to the crux of the matter, which is the question of whether or not there are right now in the state of New Jersey about 90,000 kids who are arrested in a given year. Of that 90,000, approximately far less than 400 of them were waived last year. So we're talking about 0.5%. In terms of Essex County.
Are you predicting that number will probably stay the same in the future?
I'm predicting that that
up?
number is not going to be substantially different because the only thing that this law does is eliminate what was a cumbersome and difficult process to determine whether or not someone was waived. The law, as it existed, the case law was that there was a heavy, heavy burden for the defense to overcome in order to show that there was a sufficient amount of rehabilitation likely to substantially outweigh the state's right to try him as an adult.
Now, Barry Altman would probably say that what you saw was cumbersome was due process.
Well,
exactly.
No, I would say
Well,
what I would say is
that's just the point.
What I would say is there were very few cases that I can come up with where the judge denied the prosecutor's right to move the case as an adult case. In other words, the case law was such that if a prosecutor asked to have the case waived, the likelihood was, if it was a Chart 1 offense, which is, we're talking about the murder, armed robbery, aggravated sexual assault, and those other kinds of offenses, that it would be waived.
Barry,
and as a result of that, the defense attorney had to hire an expert to come in and do some Houdini speak and say there was a likelihood of rehabilitation.
Let me ask Barry about that
and
part.
It took about a year.
But are you saying the legislature passed this bill because the burden on defense attorneys was too great?
No, I'm saying that the legislature passed this law because the case law said, essentially, that if there was a likelihood, if a waiver was filed in certain kinds of cases, that the court should waive them unless there was an overwhelming reason not to.
Barry?
Of course, every hearing is cumbersome. A trial is cumbersome. The Bill of Rights causes all sorts of difficulties for prosecutors, but our founding fathers found that those things were necessary in order to get reliable results. Now, the prosecutor is going to be making this decision without having a judge looking over his or her shoulder. A judge could demand evidence from the defense and from the prosecutor, and over a period of time, however cumbersome it might be, we would be able to achieve the right result. Having prosecutors decide over a very short period of time those juveniles who should be waived up, I don't think does justice for the juveniles. It's not going to do justice for society, because as the Assemblywoman has pointed out, those juveniles who are waived up to the adult system are going to come back to us deformed.
But what about Patrice's argument that there's some deterrence in having this process work more quickly? Is that an argument?
Not one shred of evidence. There is not one research any place that says that putting a youth in an adult prison is a deterrent. Children do not think that way. They do an impulsive thing, and they're not thinking about, wow, if I do this, then this will happen in the future. That's the nature of a kid.
Are you honestly saying that you think that a kid who was incarcerated for 2 years under the juvenile code, that same adult who was incarcerated for 10 years is not deterred for 8 more years than he would have been had he been
We need a 15-second
released?
answer, Mary, because we're going.
He's deterred for the time he is there. It is not deterring him when he goes out on the street again and decides he's going to do an impulsive act. That does not deter him. It does not keep our
Unless
streets
this
safe.
bill deters all juvenile crime, we're going to have to come back and talk about this issue again. So thank you, Patrice, Mary, and Barry. That's it for this edition of Due Process, but we hope you'll join us next week when we'll be back with another pressing issue of law and social justice. Till then, for Sandy King and all of us here at Due Process, I'm Raymond Brown.
This case is about one thing very simply. Nathaniel Abraham did exactly what he said he was going to do. And Ronnie Green paid with his life. This case involves the law of murder and the law against assault with intent to murder. I want to discuss with you that law a little bit because the question comes to mind, what about a child who kills? What about the law then?
Major funding for Due Process was made possible by the New Jersey State Bar Foundation, committed to educating the public about the law. Additional funding was provided by Lawyer's Diary and Manual,